going to go into questions now. Let me just do a quick question check. How many questions we have? Oh, we've got a lot of questions, 36 questions. So we will jump right into the questions. This first question is a question that we hear all the time. So we're going to start with this one. It's from one of my favorite managers. How would you approach a board who does not want to take any action other than placing a lien for the non-payment of assessments? They were burnt in court by a judge ruling in favor of the homeowner, so now they don't want to do anything. They don't want to take any actions. Won't they have the inability to collect assessments after a certain period? So short answer is yes, 6 years. We have a 6-year statute of limitations to collect the debt. If you have a cheat sheet on this subject, I would appreciate sharing. Any information would be to my benefit. So I would send this to this particular person. I would send a cheat sheet on the secrets of collecting assessments. And I would just say that, yes, there are times where, the judge may burn the association and maybe not give us all of our attorney's fees, or, occasionally an owner will win if the association somehow made a mistake on their ledger or something. But 95% of the time, if you file a lawsuit against the owner, you're going to get the judge to order the full amount that's owed, and the owner is going to have to pay it plus reasonable attorney's fees. So I think the approach of just leaning the property, people get word of that and they're just going to not pay because they know the only consequence is that, hey, there's just going to be a lien on my property. So I do think that you should be pursuing the files that have, when we do that credit review and we come back to you and we say, hey, this person is collectible, those are the ones I think you should be pursuing. Okay, next question, number 2. We recently purchased a townhouse condo in Prescott and lived there during the summers. The builder is still managing the HOA association, and according to the CC&Rs, does not need to turn over the management of the HOA to the residents until he's completed the remaining 4 structures in progress. He's been a great builder and he's done nothing we think is suspicious, but we have not seen any financials as to the health of the association or the size of the reserve fund. Can we see current financials? And is he required to distribute this information to residents annually? If so, how do you suggest we approach him gently about seeing them? Great question. So as a reminder, every association, even when under developer control, should be having an annual meeting every year. And that would be a great time for the developer to update the board, and the developers might be the board still at that point, but to update the residents. This is what our financial situation looks like. Here are our problems. Here's our solutions, kind of thing. So encourage the developer control board to have an annual meeting because owners want to hear more information about the association. Secondly, you can make a records request to see the current financials, the year-to-date budget, and the reserve account balance and the reserve study. All you need to do is just put that in writing, remind the developer that they have 10 business days under the law to provide it to you. Okay, we also have a good cheat sheet on a checklist from developer to homeowner control on our website that I would encourage you to take a peek at. Okay, question number 3. Is it okay to send courtesy notices and citations in the mail, and do they need to have signature or send them by certified mail? If they do not pay, what is our next step? So I would recommend that you send any notices to owners regarding delinquencies or violations by U.S. mail. I would not send it by certified mail unless you're required to under the law on something. Why? Because most owners who are delinquent or have violations never bother to pick up the certified mail. So then they'll try to say, oh, I didn't get it, type of thing. So we typically send everything regular mail unless we're required by some, particular circumstances to send it by certified mail. Let's see. If they do not pay, what is our next step? So take a peek at our cheat sheet, Secrets to Collecting Assessments. So if an owner doesn't pay, I would lien and then send it to the attorney to do an evaluation if you should do a foreclosure or if you should do a justice court judgment action against the owner. Okay, question number 4, regarding whether Arizona HOAs can prohibit group homes. Does this pertain to single-family homes with multiple generations living in that house? Great question. So when you have a multi-generation family living in the house, like grandma, parents, kids, grandkids, that's considered single family under Arizona law and under the laws of most of your cities. Just it seems odd because there's probably a lot of people under one roof, but it's still considered single family. Okay, the next question, number 5. We have a hazardous tree leaning towards a house. It could potentially fall onto the house and cause personal injury that would be life-threatening. There is a work order for cutting the tree that is 4 months old. We've made many requests discussed during board meetings. The board has not taken any action in over 3.5 months. What is the liability to the association and the board if there is a personal injury and the co-owner sues the association and the board? So I don't know if the tree is an association tree. So that would be a fact that would be important for me to know, like, is it located on the association's property? If it is, I'm very concerned. The board needs to handle this like pronto. If it's on another owner's property, it's an owner's tree and it's leaning toward another owner's house or that owner's house, there's less urgency. I mean, obviously we want this taken care of, but it's not like we're going to be held liable if the tree falls. Obviously I would continue to contact the owner. Self-help should be considered. Like the association's charting needs to get dialed in on this right away and start sending letters. Question 6. In your firm's cheat sheet, the board director removal process, the last sentence states, finally, it is important to remember that if the board receives a valid petition for removal, but the board fails to call, notice, and hold a special meeting within 30 days after such receipt, the board member subject to the petition will be deemed to have been removed from office effective at midnight of the 31st day. What is throwing me off is the verbiage office. My question is, if we don't hold a meeting, the director can be removed from the board without voting. Our CC&R says the director can be removed from their officer position by the board, but a director can only be removed from the board as a director by a vote of the community, and they were voted on. Therefore, they are voted off the board. Okay, so the question is, if we don't have this special meeting after we get the removal petition, can that director really be removed from the board without voting? So the answer is yes. State law says that if the board doesn't have the removal meeting, they don't notice it, they don't hold it within 30 days after the receipt of the petition for the removal, the board members who are subject to the petition are deemed to have been removed. So at midnight on the 31st day. So even though your documents say another thing, state law trumps your documents. And we have a great cheat sheet on the board member removal process. I encourage you to take a look at it. Okay, question number 7. What are the legal requirements or best practice for allowing homeowners to contact a board member directly? We have a management company that provides a portal, a number for our property managers, an emergency number, and an email address. So, typically what happens is if the association is managed by a management company, all communications for the board go through the management company. That's just kind of how it works. If you're not managed by a management company, then the board should give out a contact information for in the event of emergency. Here's how you contact, somebody. So what are the legal requirements? There really aren't any legal requirements that are under Arizona law, but the best practice would be have a place that is easy to find, like on your association's website, letting people know where to go when an emergency arises. How do they contact the person? What's the best way to handle it? Question 8, our master association is raising their fines for violations from $25, $50, and $100 to $250, $350, $450, and $550. In my opinion, this is an excessive increase. Are the allowable increases controlled by state statute or other laws? So no, they are not. And honestly, it does seem a little high, but I would have to read it. I think it's probably defensible, even though it starts at $250. Okay, let's see. Number 9, is there a law which prohibits for any reason preventing homeowners from gathering signatures on a recall petition in advance of a condo board election? Well, I think that you can only, I suppose if the petition isn't dated, you probably can get away with it, but I think it would be best to see start the petition once the members are seated on the board and are actually board members. Question 10, what's your advice on how to deal with a rogue board member who continues to harass our management company employees? Unfortunately, I know firsthand all about this in many different ways. So, okay, so we've got a great blog that we sent out yesterday on HOA condo board infighting. Another option would be to contact us for a boot camp. When you have those rogue board members, you really do need to nip it in the bud. And one good way to do it is to have me come in as a facilitator. I already know that there's a problem. I know the board member, I know what the board member's doing. And I, in a very direct way, we talk about the issues in a boot camp and we resolve the issue before we leave the room. Another option when you're dealing with a rogue board member, I know I'm dealing with this, unfortunately, with one of my associations that I'm a board member for, is the rest of the people on the board need to stand up to the board member that is bullying the management company and say, enough, no more. This is not acceptable behavior for a board member to be treating our manager in this way. And everybody stands behind and agrees, stop it. And that's a very good way to do it. Now, what we typically see is everybody sits back because they don't want the conflict. And maybe they say to each other, like, oh, I don't like it when she does that, or makes me uncomfortable, but they never actually say to the person, stop doing it. That is the only way to get them to stop. And maybe, people don't like that type of confrontation, that maybe you have me come in and do it in a boot camp so that we address the issue. One just kind of parting comment, my office wrote this on the questions. I agree. Dysfunctional boards seem to be a theme this summer. We're seeing a lot of problems with boards not getting along, a lot of problems with high level of dysfunction. So really, if you're out there and you're struggling as a board, now is the time to think about setting up a boot camp where we come in and help you try to solve that dysfunction. And typically, August is a quieter month, so it's a great time to work on something like that. We could set it up all by Zoom, and it could be a really effective tool to help you go into the last quarter and a half of this year with getting rid of that dysfunction. Okay, next question, number 11. Is there any means by which either the board or the community can impose an education requirement to serve on the board? It would have to be in the bylaws if you're going to do that. A requirement would have to be in the bylaws if you're going to do that. Okay, question number 12. How or can we limit the number of group homes in the community? So we have a great cheat sheet on federal laws that talks about group homes and the fact that they are, protected under the Fair Housing Act and can't prohibit them in an association. The associations really can't limit, meaning like we couldn't pass a CC&R amendment saying only 2 group homes are allowed. But what you could do is check with your city, town, or municipality. They have limitations in terms of how many group homes there can be in a certain square mile. So you may want to check into that. Question 13, how long does the HOA have to respond to an appeal request? Check your documents. I don't know, there might be something in your documents on this, but I would, respond probably, like within a week would be what I would suggest. Question, or respond to them that, hey, we're having a meeting on August 15th and we'll be discussing it then. So they're aware of what's going on. Question 14, can an HOA use funds from the operating to pay for a capital project and not the reserve fund? That'd be a good question for your CPA. I think yes. The opposite way is where it becomes more problematic. They're using money from the reserve fund to pay for operating costs, and that can be challenging. I think it can be done, but it's something where you typically have to pay back money, hopefully within the same year, but talk to your CPA. Question 15, we have a homeowner who built a garage without permission and did not follow the setback requirements in our association's documents. How do we handle that and without a violation schedule other than a $50 a month being out of compliance? Now they want to sell. Can we negotiate a larger fee? So we have a great blog on Quick 411 on unapproved architectural modifications that I would definitely encourage you to take a look at. We're going to be sharing that here with you today. So a couple things. I don't know on the setback, is it a city setback requirement or is it a HOA setback requirement? If it's a city one that they violated, you could report them to the city. If it's, the association setback requirement, just because our requirements typically going to be more restrictive. I would just note, on the property, on the disclosure statement when they go to sell it, that, hey, this is a violation that needs to be corrected and the buyer and the seller are going to have to work this out. I'd also start sending letters and fining the owner for the violation. Next question, number 16. Our property management company has not been timely with emergency e-blasts, such as failing to alert us before water shut off. Our board secretary volunteered to do this. The property manager said it would be a privacy violation for him to share email addresses of owners with our board. Is that correct? I don't agree with that. I think that if the management company isn't doing it fast enough and the board wants to send it out through an email list, I'm totally fine with the board doing that. Okay, next question, 17. And I'm okay with the email addresses being shared with the board, but I would make sure it's clear that they're only supposed to be used for the intents, the purposes of, dumping it into a file to send out an email blast. And if they get off the board, they should not be using those emails for any other reason. Okay, question number 17. I live in a planned community with public roads. We cannot regulate daily parking. We have a rental that is running a business from their home. Their employees park there and then leave in the work trucks. We sent a letter to the owners to no avail. Is there anything else we can do to stop the employees from parking in front of others' homes all day, every day? So you have public roads and you can't regulate daily parking on the public roads. I'm assuming that it's not in your CC&Rs. The employees are parking, I'm assuming, on the public roads. We sent a letter to the owner, but the owner's not responding. I maybe check with the city to see if the owners are violating any city requirements. The employees are violating any city requirements for parking. I think that sounds like your best option because the roads are not, part of the association. You're not able to, regulate downstream street parking. Okay, next question. Our HOA starts their meeting with the Pledge of Allegiance. What do you think about that? I think that's great. I wish more associations were patriotic and did something like that. Number 19, we recently had a board member pass away and are left without a quorum. How do you conduct business? Well, I think you need to put the word out there that we need another board member. In the meantime, do your best with less than a quorum to handle the affairs of the association. But you should be actively looking for a new board member to replace the deceased board member's position, and I'm very sorry for your association's loss. Okay, question 20. Can you please define recording of an HOA open meeting as a result of Senate Bill 1039? You mentioned audio and video. However, we use AI note takers that only transcribe notes so that we aren't scrambling to take notes during the meeting, as the secretary is also the treasurer. I think that AI note taker information would be considered a book and record of the association. So, I think that would have to be disclosed if an owner asked to see it. Question 21, should the board of an HOA provide charity gifts to SRP or other charities with HOA funds? I'm assuming that would be kind of like a call to action in the summer, like help pay somebody else's bill who can't pay their bill. Although I am in favor of those programs, helping other people, I'm not in favor of the HOA spending association money to do that. Question number 22. I'm just going to do a quick little question check to see how many we have. 42. So we're exactly at a little bit over the halfway point on the questions. Okay, can we hang a sign with a camera picture and smile as a deterrent even if we don't have cameras? I would not do that. I think that is misleading. And just so you know, we have a cheat sheet that's going out on security cameras that's going to be released very soon, likely later this month. So stay tuned. It's going to be all about security cameras. Okay, question number 23. How can we stop a homeowner from having a garage sale every other weekend? It seems more like a business than the approved HOA twice a year garage sale. I think right there you just kind of answered your question. We're only allowed to have a garage sale twice a year. and we've got an owner who's doing it every other weekend. So I think we just need to send them a violation letter. And if they don't comply, escalate it to the attorney. You may also be able to contact the city to see if there's any sort of a violation there with the city. Okay, next question, number 24, from somebody I haven't heard from in a very long time, but great to see you here today. What ramifications can there be if HOA community executive session information is not kept confidential and is released without board authorization by a community manager? Ooh, good question. So anything that happens in executive session needs to be confidential. It should not be disclosed to anybody, and that includes the manager and all the board members. So how do we handle it if the manager has loose lips and is talking about these things after the meeting? There needs to be like a censure by the board. And maybe we need to go to a higher up in the management company and let them know, hey, this is happening, your manager, and we're not happy about it. You need to notify the manager to stop doing it, because it's potentially putting our association in a very bad position of confidential information being, released to non-board members. Okay, question number 26. Our HOA raised the fine for reckless driving in the community to $1,000. We have a part-time security team who has no training in this area. Any homeowner can report the violation and the violator will be fined $1,000. Is this policy legal? I mean, probably not, based upon what you're telling me. I mean, you probably need to have a speed gun, or maybe you'd have to have formal training about reckless driving in order to be able to justify that, I think. Okay, question number 26. Our CC&R specifically placed the assumption of risk on the homeowner for personal injury and property damage from golf balls onto the homeowner's property. The CC&Rs further state the association is not responsible for installing screening devices or trees to limit errant golf balls from causing injury or damage. Does case law support this type of CC&R language? Honestly, I'd have to do a little research and spend some time looking at that. But here's what I would say. If your CC&Rs, the contract, specifically say, hey, we're not responsible for this, and if you want to install a screening device, you certainly have the right to, I think we should be on solid ground. I'd have to, do more, selective research on any case law from around the country, but that's my initial reaction on that. Question 27. Is there a state agency or entity that we can go to force the Master Association to actively manage common area? Well, yes, you could go to the ADRE and file a complaint. You can file a lawsuit against the association. Those are two remedies that we talked about today. Question, or run for the board yourself. Okay, question 28. What if there's a violation that is connected with the 2-week grace period? Then the same violation is committed again and again, but always corrected within the 2-week grace period. Okay, really good question. So the trash can violation is a really good example of this. So if you have an owner that's a habitual trash can person, doesn't put trash cans away, you just need to structure the letter, the violation letter, in a way that says, you're a habitual, basically, trash can person, and show them the evidence. And then say, anytime you do this going forward in the next 6 months, you will be levied a fine, of X dollars. And this is your notice and opportunity to be heard. So they realize that they can't play the 2-week grace period game anymore. Question 29. What do you suggest as the schedule for the various letters? So for this friendly reminder letter, it just depends on what the violation is, because, some violations take longer to correct, but I would say 10 days, would be a good, respond or correct within 10 days for the first violation letter. For the second one, probably 30 days. Question 30. Is it legal to send a courtesy notice and then fine the owner for a second violation within 90 days after the owner corrected the violation and documented it upon receiving the courtesy notice? But the fine was not stated on the courtesy notice and the fine letter said it was. Again, this is kind of the exact same example I just gave you. The letter has to set it up correctly. It doesn't sound like the letter that was sent, second courtesy notice, but second violation notice, set it up right. So you can't just go right to fines, right? The statute says you got to give notice, the violation, opportunity to be heard, and then fine. Okay, next question, number 31. requesting enforcement of violations and the member's right to a hearing before fines are imposed. Does the same process apply when the amenity access is revoked? Our CC&Rs require an initial warning before issuing fines, but this step has not been applied when restricting amenity use. Could we be in error by revoking access without following the fine schedule? No, I don't think so, because revoking privileges used an amenity are not a fine. A fine is a monetary amount. So I would just say, I don't know what your sections say about revoking the ability to use something for a violation or due to a violation, but that would have to be followed. I don't think that you have to have, you don't have to follow state law regarding fines, but you would have to follow whatever your documents say about what you have to do before you can revoke privileges. Okay, question 32. Our violation fine process provides courtesy letter. Then if it's not remediated, a second or third letter after 2+ weeks, although the property manager may not get around to issuing the second or third letter. Is it a good practice to have these time-based fines in addition to a standard fine list, depending on the violation? Time-based makes sense for violations like weeds in a yard, may only take a week or so to schedule a service, but not for things like parking violation or pet waste, as those are a single instance. It doesn't take 2 weeks to remove a car or pick up pest waste. We are considering adding a list of standard fines to our enforcement policy. So the question is it good practice to have time-based fines in addition to the standard fine list? Probably what I would do is just have like a catch-all phrase in your, violation and fine process that just says the board can deviate from this if, the violation, can be cured quickly, or it's health and safety issue, and this fine process is a guide, but the board can deviate it from whenever it needs to, basically. Okay, question 33. If a homeowner adds tile to their front walkway, which is a limited common area, and they slip and fall, is that the HOA insurance or homeowners insurance liability? A limited common area is still a common area. I mean, it just depends. Probably both. Claims will probably be made on both. If it's the walkway and no one else has access to it, it's possible it will just be the homeowner's liability policy. But if it's a walkway that other people can cross over to, it probably is going to be a claim on the association's policy as well. 34. What are some options when a homeowner refuses to accept communications, such as demand letters via U.S. Postal Service? Well, like I said earlier, I'm not a big fan of sending things by certified mail because they just never go and pick it up and sign for it. So I am a fan of sending it by U.S. mail. You could also post it on their door. You could also email it to them. Once it's in the mailbox rule says once the association mails it and it's the correct address, it should be, it's considered received. So within however many days later. So if a homeowner refuses to accept communication, I would still continue to send them things by U.S. mail because it is a valid way to communicate with them that's legally recognized by courts. I'd post it on their property and I'd also email it to them. Just send it to every possible way. I'd also pick up the phone and be like, hey, why aren't you responding? Or why is this violation still existing? Okay, question 35. Do ADRE judgments have the same enforcement ability as lawsuits? So generally speaking, no. It's just a piece of paper saying X violated the documents or X violated state law, and it really doesn't give us any, subpoena power or ability to hold them in contempt. Okay, question 36. Our HOA board is still under the builder, which will transfer the homeowners within the next 9 months. Our development is 6 years old, and we still have not been provided a violation and fine policy. Who is responsible for the homeowners to receive this policy, or what is responsible? I mean, they're not required to have a policy, a fine and violation policy. So, I mean, you can ask them if they're considering it, but they're not required to have one, and they may not have one. If they do have one, just make a records request to see it. Okay, question number 37. Do our documents have to be very specific about violations and the fields we can change, or will a general reasonable fees work? I prefer fine policies that are more open-ended and aren't so boxed in, this for this, that for that. X for this, X for this, second notice. I'd prefer having a more fluid one where the board can just, levy reasonable fines. Question 38, are there Arizona laws that dictate good standing to run as a board member? So no, there aren't. You look at your bylaws. Typically, you have to be an owner. And typically, unless it says that you have to be current on your assessments or no violations, typically it's not a good thing, but you can't disqualify them for that unless it's in your document saying they can't, be delinquent or whatever to serve as a board member. Question 39, can an HOA use surplus funds from the previous year along with some reserve funds to pay for a capital project? Check with your CPA, but I'm not opposed to that as long as the minutes reflect, what's being done. Okay, next question, number 40. My understanding is that due to recent legislation, HOAs with governing documents recorded after 2015 no longer have the authority to enforce parking rules on public streets regardless of the documents, as many cities have restricted that authority. Could you please clarify how this impacts a community's ability to regulate street parking? Well, a couple things. This is kind of a loaded question. This law that did just, go into effect, last year, it's complicated. It applies only to planned communities, and it applies only to planned communities where the streets are public streets. And so I don't know if your association is one of those associations or not. Go to our blogs on our website. We have a lot of articles on this that I think would be helpful to you as you navigate answering this question. So question number 41, what is the process to overturn an ADRE decision versus traditional court litigation? Actually, really kind of interesting. So if you don't like a decision that's made by an ADRE judge, you can appeal it to Superior Court. If you don't like a decision that's made by a Superior Court judge, you can appeal it to the Court of Appeals in Arizona. A couple things, if the ADRE decision, once you appeal it to Superior Court, they make the final decision and it's over. In a traditional court litigation, you can keep appealing it. So if you don't like your trial court judgment, you can appeal that to the Court of Appeals. If you don't like that, you can appeal that to the Supreme Court of Arizona, et cetera, et cetera, et cetera. Okay, last question for today. Does just the courtesy letter have to give the opportunity to appeal or vary violation letter that follows for the same violation? This gives homeowner the opportunity to appeal every letter. So does the courtesy letter have to set up the fine with the opportunity to appeal? Apparently your association keeps giving the opportunity to appeal on each letter, and that's probably not needed. The only time that you give them the opportunity to be heard is when you say, hey, I'm going to levy the fine of X, and you have an opportunity to be heard. If you set the letter up right, if it's going to be a repeat fine, you got to set the letter up right saying, hey, we're going to fine you $100 a month for every month that you don't have the lot in compliance with landscaping. And here's your notice of opportunity. Here's your notice and opportunity to be heard. Respond to us within 30 days or 10 days or whatever. And so really just the letter where you're setting the fine up has to have that opportunity for, notice and opportunity to be heard, be processed. And that could be in any of the letters, depending on where you're setting up the fines. Okay, so we had a great day today. We got through 42 questions, which is a new record for 2025. So that's great. And we got through them in about a little over 34 minutes. So that's amazing. We also had today a new record as well. We had live 220 people listening to us on Zoom or Facebook Live at our peak today. So that is also a new record for 2025. So 220 viewers at peak and 42 questions. Amazing. Thank you so much for being here. I know it's so hot out right now, but maybe a great time to be listening in on these classes, right? Okay, let's talk about what our upcoming classes are so that you're aware of our next free opportunities for you to learn more about association law. So we have our first Fridays in August, and that is going to be August 1st at 9 a.m. And it's, of course, going to be live on Zoom, just like it always is. You can get more information by going to our website. to submit a question, and we just hop online on Friday, August 1st at 9 a.m., and I'll be answering questions rapid fire. We also have a class in August. It's class number 8 on Tuesday, August 19th. From 11 a.m. to 12 p.m. on Zoom and Facebook Live. And we're going to be talking about mastering HOA and condominium finances. And we're going to be talking about what do you need to do to create the 2026 budget for your association? How do we read financial statements? What are our board members' fiduciary responsibilities? And how do we understand reserve studies and reserve accounts? And that's going to be a great class on Tuesday, August 19th. I'm going to be having Hayden DiLorenzo and Madeline Gegg from my office are going to be teaching that class for me because I'm going to be moving my son into college. I cannot believe it, but I am sending him off and we are moving in that morning. And so I won't be there for that class. So you will have it all set up and it's going to be a great class with Madeline and Hayden. But I won't be there that day. Lastly, before we sign off today, let's consider liking us on Facebook and following us on LinkedIn or Instagram, just so that you can stay up to date on what's going on in the HOA and condo industry in Arizona. So consider liking us on our Facebook page. We're very active, putting a lot of information on Facebook, LinkedIn, and Instagram. Great resource for you to have pop up on your screen just to let you know about important things that are happening. Lastly, if you wouldn't mind, we would genuinely appreciate it if you would consider giving us a Google review or a Yelp review today for attending the class. We need to give feedback to the different cities that we teach these classes for, so it's very helpful if you don't mind doing a quick Google review or a Yelp review as to whether or not you like these classes and do you find them helpful, and anything that you'd like to say about our firm would be very, very much appreciated. Okay, everybody, have a great rest of July. Can't wait to see you again on August 1st for our first Fridays, and enjoy the warm weather. And thank you for everything that you're doing to make your associations better. We appreciate you. Take care, everybody.